Hello, Mr. Henley.
Good morning, Judge.
It's afternoon.
It is afternoon.
Are we ready for me to call the case and to proceed?
I am.
The recording is on. This is the time set for hearing on Mr. Gatchick's request for removal of the presiding disciplinary judge for cause pursuant to Arizona Supreme Court Rule 51D and then the civil, ARS 12409. This is your request, Mr. Gatchick. I have been provided, as you can see, with a lot of materials here. Uh, I have read through them, but I will just be honest with you, sir. I got kind of lost in there with all the things that you were bringing up and exactly what is connected to what in terms of understanding the basis for your request. What might be helpful, and I haven't seen the complaint that the state bar has filed, but what are the allegations that the state bar is making as to Mr. Gatchick? Because that I think bears on the relevance of what he might be seeking to assist him in this disciplinary matter.
Yes, thank you, Judge. The primary basis of the complaint is a number of online posts that Mr. Gajic is alleged to have posted on various online platforms that are denigrating to the judges, other elected officials, all in violation of 41B7, 8.2 ER 8.2. I believe that we have another one. I don't have the complaint here in front of me, but those are the primary allegations, and they surround a number of ongoing posts. These are similar to his prior disciplinary hearing that resulted in a 1-year suspension. The same type of behavior has continued since that original imposition of suspension, and has in some ways increased. The other primary allegation is that during a hearing related to an injunction for against harassment, he was that it's all in the complaint. But
Yeah, I saw. I wasn't given a copy of the complaint or the response. I was just
I'm
given
happy
every.
to I'm happy to provide that to you, Judge, if
Yeah,
you'd
if you
like.
could put both of those there so I could take a look at those, because I did see where in some of the materials that Mr. Gatchick prepared, there was, it appeared to be things that were online. So
Yes,
just
and
put it that.
I'll provide a copy of the complaint and anything else that the court may want. The
Okay.
the primary issue that we had with the hearing itself was that it
I'm
related
going to
to.
object to this, Judge. This is beyond the scope of what your question was. It's not argument at this point. It's just what the complaint
I
was.
didn't know what he was going to say, so I'm going to let him say it and then I will strike it after I hear
All right.
your objection. So, Mr. Henley, if you could continue with
Sure,
your
sure.
statement.
The complaint also makes allegations regarding the hearing wherein there were statements that were made that were considered to be false in violation of 8.4C. So those are the primary allegations and violations that the complaint alleges.
Okay, well, thank you. Uh, Mr. Gatchick, this is your request to remove uh, Judge Lisa Vandenberg from sitting on your
Mhm.
matter. I will tell you, although I'm a former Superior Court judge, I don't know, and I know I believe Judge Vandenberg was also. I don't know her. I don't know if I ran it we might have been at some of the same, like, judge conferences, but I certainly don't know her. And I just want to make that really clear. So, to allay any concerns you might have about,
Mhm.
you know, members of the judiciary being cozy with each other, because I don't even know who she is. So, okay, sir, this is your motion to
All
have
right.
Judge Vandenberg removed as the presiding disciplinary judge. And I kind of want you to help me out a little bit because I couldn't follow exactly how everything was related in terms of your motion and things you had filed, including something we referred to like down in Pima County with Judge Browning. So if you can please help me, sir, understand why you believe that Judge Vandenberg, there is a basis for her removal for cause in view of the total picture before we have going here. And by the way, knowing that I just learned that there was formerly disciplined, uh, was she the judge in that matter, or was there a different?
No.
Okay, okay. So, sir, you can proceed.
All right, Judge. So I don't think you remember me, but when you were a Superior Court judge in Pima County, I was actually public defender. I worked for Susan Kettlewell
Right.
and Bob Hooker and Hirsch. I've been a lawyer for 20 years, Judge, and I never had any discipline, nothing, not even diversion. And I get appointed, a court appointed, a man charged with sex trafficking, a black man. Guess what? He happens to be innocent. And I try to prove it. And then the simple story is that Rachel Mitchell takes me out because black men aren't allowed to be innocent in Maricopa County.
Whoa. Who took, help me, I just didn't, who took you out?
Rachel Mitchell.
And Rachel Mitchell is
The Maricopa County, she's the Maricopa County attorney.
Okay. So did she file something in court to get you disqualified?
No,
Help
it
me
was
understand.
so first the prosecutors tried to get me disqualified because they were alleging I was a sexist. And I am not joking. That's literally what the allegation was, that I was
That
a
you're
sexist.
what? A sex offender?
No, that I'm a sexist.
Oh, that you're a sexist. Oh, okay. I was going to say, I had heard, there's nothing about you being a sex offender in here. Okay. Who said you were sexist?
The prosecutor on the case, her name was Lacey Fisher. And then I had filed a motion to disqualify the prosecutor in the prosecutor's office for misconduct. Based on the
Maricopa County's,
Yes,
Maricopa County attorney. Okay.
Right. And it was a court appointed case, right? And there's a lot, trust me, there's a lot of details in the underlying criminal case. But I was just trying to defend the guy. And it even got to the point where we uncovered the case agent. If you're familiar with sex trafficking in America, it's the frontline episode on the HEAT unit, the Human Exploitation and Trafficking Unit that try to stop trafficking, Cindy McCain's unit. It's a lot of political clout behind the unit. Anyway, this is a part of that police agency. The leader of that group, her name is Christy DeCuffle. She was bribing, and I know it because it's in writing, bribing a defense witness who said my client, a guy named Jamal Pennington, was innocent. And I know that because we found her and we talked to her, and she actually gave us the Facebook, or the state gave us the Facebook records, proving that the case agent was talking to my witness to change her testimony in writing. That's undisputed.
Who's the case agent?
Christy DeCuffle.
DeCuffle. Okay, so she's a police officer in charge.
She was.
Was she Phoenix PD or Maricopa County PD? I mean, yeah.
Phoenix Police.
Okay.
In the middle of the case, she quits and retires and moves to Georgia, by the way.
Okay.
And so I'm trying to defend Mr. Pennington, and then that's when, I don't know how much you want me to get into the weeds, Judge, but one of the judges files a bar complaint against me saying that I was mean to him based on his ruling. And then the other judge was a guy named...
What judge was that? What judge was the first judge?
Justin Beretsky.
Okay.
And then the other judge is a guy named Chuck Whitehead, who I asked to recuse himself off this case. Just a little bit more backstory. Right before I started on this case, I had been assaulted in court. I don't know if you know about that, but I'd been sucker punched in court. And then I was having a contract dispute with Maricopa County because it was a court-appointed case and all that. Anyway, I had asked...
Were you attacked by a client in court?
Yeah.
Okay.
And so that was right when I first got this was in end of 2018. And Judge Whitehead was on the committee that approved contracts for the county. So I had asked him to recuse himself because I thought maybe there was something going on there, with the contract and the case, because he was the first judge on the Pennington case. And he takes himself off the case. It wasn't a problem. I find out, because my investigator told me, he was in court with a hearing with me. He told me that Judge Whitehead goes to strip clubs during the day, that he's there frequently during, and he's not the only one. Some other lawyers told me the same thing. It's a place called Bourbon Street, and I want to say I don't care. I don't care what judges do with their free time. It's none of my business. But he joins the bar complaint against me on a pretext to cover up what he's doing. And
Going to
everything,
strip clubs?
yeah, going to strip clubs during the day, and he's still doing it. And not only that, Judge, he's leaving business cards at strip clubs because everybody knows who he is and what he's a judge. And I would think a judge going to, even just buying a car or buying a house, he doesn't get to use his office for personal benefit. That's my impression. That's my opinion. And I want you to know, Judge, everything I'm telling you right now so far, I said directly in testimony to the Senate Judiciary Committee 2 weeks ago during a hearing. It's on video. The Senators Fincham and Wendy Rogers and a few other senators were there. The next day, Marette Vasella, Chief Bar Counsel, talks to Arizona Daily Mirror. She did not dispute a single word of my testimony, not a single word of what I said so far to you and what I'm going to say more. But everything I am saying right now is undisputed. And this is the kind of stuff that I'm putting on Twitter. Because what else I'm going to do, Judge, all day? What else am I going to do? For 20 years, I'm a lawyer without any discipline, and they decide to steal my livelihood from me. I don't get in here. I am the only judge. I'm the only lawyer in 100 years, and this is undisputed. The only lawyer in 100 years not to get a hearing on the merits, to consent, or default. That is undisputed. I said that right to Marette in Senator Anthony Kern's office. If you know who Senator Anthony Kern was, he was chairman of the Senate Judiciary Committee a few years ago. Great, so you know him, and he was there?
No, I don't know him.
Okay.
I have read his name as being in the legislature. That's
So you know,
like I said.
at least you know the office.
Okay.
I was there with Marette and Joel England, who was in my law school class. He's chairman of he's CEO of the bar, and my same investigator was at that meeting. And I said that right to Marette. I'm the only lawyer in 100 years not to be disciplined without a hearing on the merits, without default, or without consent. She says, "Oh, you're not the only one." And then I said, "Okay, name somebody else." She goes, "Oh, I can't with me right now." She couldn't name anybody else because I am the only one. And that's exactly what I said to the Judiciary Committee the other day. So then I go on Twitter and I start telling stupid fat jokes on X because I have nothing else to do. And if they're going to steal my livelihood from me and be the only one, well, I'm going to get some measure of restitution. And the way I'm going to get some measure, some of my money back is I'm going to tell the world about what happened to me and what happened to Jamal Pennington, that an innocent man is being framed for a crime he didn't get. And I want to be careful about this. I am not saying that, I'm not some sort of Black Lives Matters activist or Antifa activist. I am saying that Jamal didn't get his day in court, and he's entitled to prove his innocence. That's it. If the jury comes back and says he's guilty, okay, then that's what they do. This would never have happened in Pima County. There is zero chance what happened to me would have happened if Bob Hooker or Bob Hirsch or John Seaman or Don Klein, any of those people were running the county attorney's office. The only reason it happened in Maricopa County is because the state bar and all the judges are craving to Rachel Mitchell. Anyway, I go on X and I start just putting on videos from court, things like that. And then some random troll starts attacking me. It turns out it's in secret. It's Rachel Mitchell's husband. So
What's his name?
his name's Paul Stout.
Okay, that's what I want to.
Yeah.
How do you know that he's doing this?
Because Rachel, if you know who Rachel Alexander is, she told me. She's a journalist up here in Phoenix.
Okay.
She knows. So it's a bizarre little world up here in Phoenix, very different from Tucson when it comes to the state bar and social media and politics. It's very politicized up here. And he starts attacking me on X. I don't know who it is. Starts making fun of me for being assaulted. Starts putting
This is
Paul Stout.
okay, Paul South, the married to the county attorney.
At that point, he was just the fiance, right?
Okay.
So this is in like around November of 2023. And he's using his own name and his own picture. So I don't know who the person is. I just know the name and the picture. Then later on, he changes it to a troll, a guy by the name of Tilden Katz. And then he went out of control. He probably sent me a few thousand tweets alleging me that he was a law school professor, that I was guilty of plagiarism, that I had committed bestiality, that I was guilty of domestic violence, that I had a DUI, making fun of me for being assaulted, all sorts of things. This was hundreds and hundreds of tweets. Turns out that's Paul Stout too. So then I'm just asking, and I had found out at that point from Rachel Alexander that who Paul Stout was in his relationship to Rachel Mitchell. And if I could just back up for 1 second too. I had been taken off Jamal Pennington's case, and he represents himself pro per. He had 10 original counts.
Did he request that he be able to represent himself
Yes.
pro per? Okay,
Yes.
so he initiated that.
Yes.
Okay, Jamal did. Okay.
Representing himself. So I had been accused by the state bar of conspiracy theories. Fact is, 9 out of the 10 charges that Jamal was originally charged with, including all the sex trafficking counts, have been dismissed. So only 1 count remains, and they're saying he's guilty of molestation because his girlfriend had sex with a minor. So nothing for what he did, but just what his girlfriend did. So 9 out of the 10 counts have been dismissed, but I'm guilty of conspiracy theories. Anyway, before his sentencing in, I think it was September of 2023, the NAACP gets involved in the case, a guy named Andrew Miller. And they tell me, because there was a story in the Arizona Republic, so he gets involved. He calls me and tells me that he had spoken to Rachel Mitchell that day, and that Rachel Mitchell had told him that they knew Jamal never touched the minor. That one of the charges was sexual misconduct with a minor. They knew that he never touched her, but they prosecuted him anyway because he was guilty of facilitation. So that doesn't make any sense. And that then he tells me Mitchell's gonna send the case to what's called integrity review, and I actually have a copy of the text message. In that same text message where Mitchell sent to Miller, she's complaining about my tweets criticizing the state bar. And Miller tells me that my criticizing Rachel Mitchell on social media is jeopardizing Jamal's case for integrity review. She told Miller that if I don't stop tweeting about Jamal's case, she's not going to review his case for integrity review. She wasn't going to do it anyway. That was all just a lie. But the point is, Mitchell was, and I had like 3 followers at that point. So Mitchell was trying to get me to stop tweeting before Paul Stout ever showed up or was in the picture. Mitchell has been bound and determined to have me stop tweeting from day one, so nobody finds out what's going on. Anyway, going back ahead, I'm asking questions about Paul Stout, like why is she hiding him why is Mitchell hiding him? Just my usual stuff. And then August 18th, 2024, a reporter, his name is Stephen Lemons, Phoenix New Times, he asked Rachel Mitchell, who's Paul Stout. Mitchell doesn't want to answer it. 5 days later, 3 sheriff's deputies show up at my house and an FBI agent. They come into my living room to tell me I'm not allowed to tweet or post about Rachel Mitchell or Paul Stout. And if I do, I'm going to federal prison. When they showed up to my house, my neighbor tells me the next day they actually got lost and there's actually security. And I put it into motion. You can see the stills. They got lost asking for directions how to get to my house because they weren't using GPS and they didn't call dispatch. Later on, Rachel Alexander asks Sheriff Sheridan about it, and I have the text messages and I put him in the motion. He told Rachel that his deputies had nothing to do with it, that his deputies were never at my house, even though they were MCSO deputies. So what happened was Rachel Mitchell hired off-duty cops, including an FBI agent, to just scare me, to scare the hell out of me. So I would stop tweeting and nobody would find out, because obviously I have a First Amendment right to criticize government. Even though what they're saying is if a family member or a potential family member of a politician doesn't like what I'm saying, that person, that family member or potential family member can get an injunction to stop me from tweeting. That was the whole argument for the injunction. Just jumping ahead, we do the hearing. And if you notice too, Judge, when you just asked Mr. Henley the basis of the complaint, Mr. Henley couldn't tell you what the problem is with the injunction hearing. He just said, oh, well, you're gonna have to refer to the complaint, because there was no problem with the injunction hearing. Everything I testified to, everything I said, everything I read or wrote was 100% true. That's why I posted everything on YouTube and social media, because I want everybody to see it. Mr. Stout lied. He straight up lied at the injunction hearing that he used to work for the Department of Child Safety, DCS. He said something like, he testified to this in response to the judge's question, that my email to Department of DCS had caused them problems. After the hearing, I emailed DCS and asked him for a copy of his employee file, which is public record, and all you have to do is just email him, ask him for it. And they told me, we never heard of the guy. We don't know who he is. So that explains why I want the subpoena deuces taken to Department of Child Safety, is at the very least to prove he committed perjury. He also blatantly committed perjury that he wasn't Tilden Katz. And there's a bunch of stuff. I try to appeal, the judge rules against me. He sanitizes the record, doesn't mention anything about Rachel Mitchell. And I specifically filed an anti-SLAPP motion to dismiss on anti-SLAPP, First Amendment rights, that I'm entitled, have First Amendment right to criticize government. And Judge Albrecht just said, no, the First Amendment is irrelevant. He said it was strict liability. He said, it doesn't matter. The First Amendment doesn't matter. All that matters is if Stout doesn't like what I'm saying. That's it. And then I try to appeal it, but then Judge Albrecht refuses to sign his order for 5 weeks. I think it's 5 weeks or 5 months. Just refuses to sign it, so I can't appeal it until Stephen Lemons writes an article, and the next day he signs it. And then
talking about Judge Rebecca Albrecht.
No, I don't know what the relation is. It's Richard
Because
Albrecht.
I don't know Richard. Okay, and he's a judge.
He was commissioner.
Commissioner. Okay.
They might be related, but I'm not sure about that.
Okay.
And then, so this is where it gets surreal, Judge. It gets frankly surreal. And this is part of the reason I wanted the subpoena deuces taken to the Phoenix Police Department. Is I find a police report from last year where Rachel Mitchell told the Phoenix Police Department that the previous Valentine's Day, she received a package in the mail of dog feces. And she told the police it was me, right? She calls the police and tells them that I sent her dog feces. That's how I found the report, was because my name was on it. I look at the police reports. It turns out it's right there on the police reports. There's no dispute about it. So they live in a secret location. I don't know where they live. I could mail them. Even if I wanted, why would I do such a stupid thing? But even if I wanted to, how am I going to know the address? It's right there in the police reports. Her husband picked up the package from the mailbox on the 12th. And then he tells Mitchell that it's sitting on the front door on the 13th. Then I just get the recording yesterday or last week from when the police went over there to talk to her about it. And she knows everything about me. Mitchell is obsessed with me. She knows how old I am. She knows where I live. She knows my living situation. She tells them I live on a compound. She says I have goats and chickens and that I live with my parents. So she's obviously following me or watching me or hired somebody to watch me, or maybe it's the FBI. I don't know. But she's obsessed with me. And she blamed me for sending her the dog poop, even though it's 100% obvious it was her husband who did it. Nobody else did it. It was her husband, and that's clear as day. And even on the recording, you can hear Mitchell tell the police that he's the concerned husband trying to figure out what happened. And he's just trying to help her and help police because it's a major emergency. Even Homeland Security and the Postal Inspector, they're all over it because it's such a big deal. And they know it's him. But I'm the one who gets blamed for it, right? And I'm entitled to prove that. I'm entitled to prove there's a vendetta against me. And then, and I forget exactly when it was, but I get, around that same time, that's when I get the first email from Henley saying that Mitchell had filed a bar complaint against me. And I don't know if you've seen a copy of it, but it says right on there, Judge. She filed it in July of 23, but I don't get it until 5 months later. So I asked Henley, why did it take 5 months? This has been going on for over a year and a half at this point. Why did you guys hold on to the complaint for 5 months before telling me about it? And he says, it's none of your business. Why? Anyway, right on there, she says that she's ordering the state bar to disbar me because I've been criticizing her on X for months. That's literally her exact words. She's demanding I be disbarred for criticizing her on social media for months. And then I asked Henley, well, how can you disbar me for what I'm putting on social media? And he says, oh, we're not doing that. It's about the hearing, or he won't tell me what it's about. I keep pushing and pushing, and finally says it has something to do with the hearing, the injunction hearing you guys had. I go, what is it? What is it about that hearing that's the problem? And he won't tell me. So obviously, I know a pretext when I see it. I'm 51 years old. I'm too old to play make believe. I know when somebody's making stuff up just to try to bull me to back down, and they want to make Mitchell happy because Mitchell is telling them to make me stop tweeting. I know he's saying a year suspension. I'm disbarred, Judge. I'm de facto disbarred.
What's your current status legally with the state bar?
Suspended.
Are you suspended? Okay.
And I had hired, if you know Dennis Willencheck, if you know that name.
I know the name.
All right. Mark Bernovich told me to hire him. So I gave him $10,000 to get me reinstated. And this is well before any of this started. And then out of the blue, Willencheck just drops me and says, screw you. I'm done with you because you're a bad guy. And he won't tell me why. He takes all my money, doesn't tell me anything. And I know what happened. I know that Mitchell called him and told him just to drop me. Because he couldn't even spell my name. He didn't know the first thing about me. He couldn't even spell my name and he took $10,000 from me. I filed a bar complaint. The state bar doesn't care. They couldn't care less. And in fact, just last month, a friend of mine forwarded me an email from Willencheck slandering me, saying that I had been defaming Willencheck for some months now, off the record. I filed a bar complaint against Willencheck for breaking confidentiality, for defaming me. This is 2 months ago. They're not going to do anything. They don't care. Who am I? I'm a public defender, Judge. Why would anybody care about me? My name is Vladimir. Why would anyone care about me? ACLU doesn't care. Montgomery doesn't care. Brutenell doesn't care. Nobody cares. Why would they? I'm not one of you guys. I'm an outsider. I've always been an outsider. When I was hit in the head, I could have been killed, but that's just something to laugh about because that's funny. That's funny to all you people. Now, and then as far as Tucson goes, Judge, Mays tried to indict me for a felony. This is for class 5 aggravated harassment. And I know it went to a grand jury, and I know it was no billed. All right. So Mays, who tries to proclaim herself as this, champion of civil liberties, freedom, and the Constitution, hating on Donald Trump, whatever, I don't care. Not when you're a foreigner, though. Then it doesn't apply. And it's right there on the search warrant. It's right there in the search warrant that the basis of the prosecution is for me disparaging Rachel Alexander. It's right there. They don't even hide it. And the only reason I'm not in prison right now is because of Rachel Alexander and Stephen Lemon. That's it. If it wasn't for them, I would have been Epstein in prison by now. So and then they apparently, for whatever reason, decides to go forward with the complaint. I think about 2 months ago, I filed the anti-SLAPP motion, which, what's her name, Vanamburg, just denies, saying that I don't have even a prima facie case, even though, forget all the evidence I put in there, even though Mitchell, in the actual bar complaint herself, wrote she wants me disbarred for criticizing her on social media for months. It's right there in the complaint. How is that not a prima facie case of retaliation? Vanamburg's only justification for saying I don't make a prima facie case is I didn't put an affidavit in there. So what? There's no dispute that what I'm saying is true, and an affidavit isn't required. It's just a pretext to deny it. She's going to deny everything. Anything I try, any defense I put forward, Vanamburg's going to deny on some pretext. I'm not even going to get a hearing.
You're talking about, okay, now you're talking about Judge Vandenberg?
Yeah.
Okay, why do you think, I guess I'm confused, or I need some clarity about how whatever is going in terms of Mitchell would be translated to Judge Vandenberg.
Because Mitchell is the complainant, Judge.
Okay,
And her
well, I
husband.
guess she filed the bar complaint, and then I guess I'll look at the complaints, but then the
Right.
bar filed charges against you. There's a
Right.
2024 and 2025 one. Which one is this, or the one you're referring to?
I think it's the 2024 one.
Okay, that's the one involving Mitchell?
Mitchell and Stout, they're both co-complainants.
Okay,
And
okay.
And I had done, so the bar wanted to subpoena me for deposition. I know why they want to do it. They want to do a perjury trap on me. They don't, why do they need my testimony? If the problem is my post on social media, they have my post on social media. They have my testimony under oath. I put it all on YouTube. Why do they need me to test it, to do a deposition? It's so they can come up with a pretext to charge me with perjury. It's not that difficult to figure out. But I even told Henley, look, I'll agree to a deposition, but I get to depose Rachel Mitchell. They gave me a subpoena to subpoena Rachel Mitchell. I got the conference room. I spent $300 on it. I served her. The state bar had a problem with the timing of it. Like, when does it start? I wanted to start at 9. They wanted to start at 10. And the location, but even the state bar wasn't objecting to me deposing Rachel Mitchell outright. But Vanamburg, she dismissed my subpoena to depose Mitchell, and her only explanation was it was inappropriate. So even though the bar didn't object to me deposing Mitchell, just the details of it, like the logistics of it and how long it would last, they said I could depose Rachel Mitchell and her lawyer would be there. So
And then you said that the judge, disciplinary Judge Vandenberg, just outright denied your subpoena for Mitchell, correct?
She said it was her exact explanation was inappropriate. She issued a ruling the next day. I think it was the next day or a couple days later. And she cited rules, I think like Rule 30, Rule 26, but without saying what it was. Just said, oh, this rule and that rule. But not because of X, Y, and Z, I don't get to depose Rachel Mitchell. Just the only actual exposition of why I don't get to depose Rachel Mitchell, even though the state bar doesn't object to it, is because it would be inappropriate. I know what that means. I know that's code. I know that's code because I'm not important enough. That's why. And Rachel Mitchell is the county attorney, and she gets to do what she wants, and nobody's going to find out. And if people find out, nobody's going to care. It's not that subtle. I do the subpoena deuces taken for a bunch of things, kind of like what I've been talking about with you. And so I filed the subpoena deuces taken. The state bar does not file a response. The state bar does not object to any of them. On her own, the PDJ, Vanamburg, dismisses all of them. And it's right there. I think you saw it, where she writes, I don't know why he thinks he gets subpoena deuces taken. That's only for the state bar. It's right there in the rules. It's like Rule 41. I forget which one it is. It says right there, the parties get to use subpoenas to get written documents and records. So why would a judge, a Superior Court judge who's been working for 20 years, I would assume she knows how subpoena deuces taken work in general. I would assume that part of her rotation was the civil bench or the family court or whatever, would know that once it's not just one side has discovery rights. Like if one side has discovery rights, so does the other side. This is not a criminal. It's not supposed to be a criminal prosecution, but she's treating it as a criminal prosecution. That's the only reason she would have said that, even though it's right there in the rules. And so I have no right. To subpoena any witnesses in my own defense. I have no right to subpoena any documents in my own defense. I have no right to, and the First Amendment is irrelevant. That's what she said so far. And if you looked at my motion, you would know, Judge, I would be the only lawyer ever, I think in America, sanctioned for social media posts criticizing an elected politician. Ever. So if you know who Tom Ryan is, his brother is Tim Ryan. He posts like a madman all the time. He faked a picture of Senator Anthony Kern at the January 6th riots when he was when he was chairman of the Senate Judiciary Committee. He posted something about some case that forced his brother to recuse himself off the case. I don't have a problem with it. It's called the First Amendment. Dennis Willencheck is a psychopath. He actually was publicly saying that, this is a few years ago, that a candidate for sheriff, Nick Saban, had raped his stepmother. It was published I only know about this stuff because it was in the Phoenix New Times. He's never been sanctioned for any of that. Brian Blum wrote that tweets all the time. He flipped off the state bar in a hearing when he was supposed to be at a hearing. He said that the CIA runs the Arizona Supreme Court, and that's why the election results were fake. No problem. He gets to say that. Cherie Wright. I know her well, and so does Mr. Henley. She told me openly she hates anybody who's Jewish. She just says that openly. And she's on her website, she's lying that she went to ASU Law School. She didn't go to ASU Law School. She went to the worst law school in America. It's called Summit School of Law. But she gets away with it because she can. David Greengrass.
Okay, help me out. I'm trying to get all this fit together to see how this relates to Judge Vandenberg. So can you help tie that part together?
Sure. This was all in my motion for the anti-SLAPP motion. So when she comes back and says, I can't even raise a prima facie case of retaliation, how is it that all these other lawyers get to say whatever they want, however they want, and I don't? If I'm the only lawyer ever to be sanctioned for social media posts, how is that in itself not a prima facie case of retaliation? That's what I want to know. She ignored all that, Judge. She just said, oh, you didn't raise a prima facie case because you didn't put an affidavit in there. Okay, then, what am I supposed to do at that point, Judge? And then I think this will be the last point I'm going to raise, Judge, is just the ex parte communication. So they wanted, the state bar wants me to do a deposition. I'm not going to waive my rights. You want me to do a deposition? You serve me. You want to serve me? You knock on my front door. That's all you have to do. But they don't do that. They get a subpoena in secret because I didn't get a copy of it. They're saying, oh, well, we forgot to copy you on the subpoena. Yeah, right. Yeah, I'm that stupid. They just happened to make a mistake to copy me on the subpoena. So my mom is leaving here, Judge, 8 o'clock at night. It's pitch black. I live out in New River, if you know where that is.
I know where it is.
It's
But your
pitch,
address at Carefree, are
say
you,
it's
as part
it's
of
the same thing.
Carefree?
It's the same
Okay.
thing. It's basically,
Okay.
it's right. I'm Carefree Highway. I'm
It's
off the
north,
Care-
yeah, you're way north of Phoenix there, off of I-17, right?
right off of I-17 and Carefree Highway. It's pitch black, Judge. It's pitch black. There's no street lights. It's a dirt road. So my mom is trying, and it's a one-way driveway. And some idiot comes along, it's a long driveway because we're in the infill, comes along and just sits outside staring at her for 5 minutes. She tells me she was terrified. She almost had a heart attack because she thought it was that psychopath out to kill all of us. That's what she thought. You know what it was? It was a state bar ambushing her because they thought it was me to give me the subpoena. There is zero chance that I wasn't set up by both the bar and by Vanamburg. That's why I wasn't copied on the subpoena. And if they didn't, and let me just ask, what's his name? Henley is saying it. Well, we don't need to serve you with a subpoena because we properly notice blah, 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 blah. Okay, then, fine. Then why that stunts? Why? Why do that then? Okay, because it was for harassment. It's like sending those goons. It was an FBI agent at my house in my living room telling me I'm not allowed to use Twitter. I'm an honorably discharged Marine, Judge. I've been a lawyer for 20 years. I pay my taxes. I don't speed. I don't drink and drive. I don't even have a criminal speeding ticket. And they're treating me like some sort of thug off the boat, like I'm some sort of Nazi psychopath. So what am I supposed to do then? My rights are disposable. Not only that, they're laughing about it. Before they got into my house, I saw on the body cam, the deputy was actually practicing to shoot me. You could see it. He's actually like grabbing his gun to get it ready. When he walks into my house, you can see it. He grabs the gun. Do you know why that is? Do you know why they were practicing to shoot me? Because somebody, I wonder who it was, told him I was full sovereign. I don't know what that means. And I don't own a gun. I don't want to kill anybody. I don't want to hurt anybody. All I want to do is my job like I've been doing for 20 years. And they won't let me. And that's all I got, Judge.
Okay, thank you so much, Mr. Henley.
There's a lot to unpack here, so I'm just going to take. I'm just going to take it as easily as I can. And if you have any specific questions, Judge, or anything, I'm happy to address them. There's a couple of things I think are very, very important to clarify before we begin. Mr. Gadget's argument today, I think, would be sufficient to evidence some level of defamation lawsuits against any number of entities and law enforcement and number of different individuals, none involving the bar. They may be relevant in some other state court actions for damages, that he can believe and he can do whatever he wants to in his private life. And if he is suffering the amount of what he's claiming is retaliation and vendetta by these.
That was your word, vendetta, not mine.
He did not use vendetta. And I didn't know that. But-
She's pursuing a vendetta against me is what I
You
have.
wrote that about Mitchell.
Whoa. Mr. Gadget, this is Mr. Henley's chance to argue. I will give you a chance to respond. Mr. Henley, you can proceed.
Thank you. Like I say, the point is really simple. It may be relevant in other actions. This is a licensing action. The state bar is a licensing entity. That's all we're here for. If he wants to do whatever he wants to do in his private life, the state bar has nothing to do with that. Another clarification I think is important. By his argument, he seems to suggest, if I'm wrong, and I misinterpret. But he seems to suggest that by being named a complainant in a state bar action, that they're a party or have any interest in the bar charge, the results of the bar charge, etc., and that the state bar has some sort of obligation to the complainant as a party to the action. Rule 53 it's black and white. There's nothing at all nebulous or equivocal about this. The complainant, the submission, what they are people that submit bar charges pursuant to Rule 53. They are named the complainant pursuant to rule. That does not give them any rights as a party except notification. And that's spelled out clearly. The exact language of the rule is complainants are not parties to the action. They're not a party. And so all of the allegations about Mitchell doing something or saying, we have complainants, and I'm just going to throw a number. I don't know how accurate it is because it's irrelevant, but it's the vast majority. 90% of our bar charges involve complainants that want certain things done. And they're not a party. They're not entitled to demand anything of the state bar in pursuing our enforcement of the Supreme Court rules. To that point, with respect to Ms. Mitchell's deposition, we did not oppose Mr. Gadget's interest in deposing Ms. Mitchell. He can depose anybody he wants, including the complainants. We can't stop it. We don't represent her. So there's nothing that we can do to go ahead and stop Mr. Gadget from deposing whoever he wants to depose. The objection that we did raise with that request of his, he wanted some endless public display in the middle of a public forum. This is a tier 1 case. Clearly, there's not going to be an 8-hour deposition of any one witness or combination of witnesses without court authority. This is a tier 1 case. So that's what we were opposing and still do oppose. Any suggestion that any body seek depositions that exceed the tier 1 limitations imposed by rule. I'm just going through a couple of these things as a backdrop. His deposition, for example, as a party, the rule is clear. We don't have to serve him. The subpoena was provided to Mr. Gadget. I've never understood what he has said in his emails to me. He was included in the request for the subpoena. He was included in the subsequent issuance of the subpoena. There was a change in the subpoena because of a typographical error. It was starting at, I think, and I'm going off the top of my head, it was, according to the form, it was 2 o'clock in the afternoon, and it was actually scheduled to begin at 9 o'clock in the morning. We changed the date, and actually we didn't. The clerk changed the date, and so it's ultimately it's foolish because as a party we didn't have to subpoena him. A notice of subpoena was properly served upon him. Pursuant to the rules in the discipline proceedings, he had an obligation to show up at the deposition. That's it. The service of the subpoena, I'll be candid with the court. I certainly wanted him subpoenaed because it was my understanding from his prior communications with us that he had no intention of appearing at a deposition. And so I wanted to make sure that he was subpoenaed so that in the event he knowingly and willfully did not appear at the hearing, then that would be another violation that he would have committed during these discipline proceedings. I wanted to give him the chance to do the right thing, but certainly I am.
Up to you.
Okay. So the, so, okay, are you done, Mr. Henley?
Very briefly, to address what we're here for, which is
Yeah.
the motion to remove
Judge Vandenberg.
to remove Judge Vandenberg from the case. I've outlined in my brief how the request is procedurally defective on any number of bases. It's not authorized by Rule 26F1 of the Arizona Rules of Civil Procedure. He has not provided us with a disclosure statement. He's therefore not authorized to engage in any level of discovery at this point. He does not contain the required, his request does not contain the required affidavit as set forth by ARS 12409 and also in Ray Abishan 233 Arizona 62 302 Pacific 2nd 889. Substantively, as he's made his arguments today, he's just relying on conclusory beliefs that are based on the judge's adverse ruling on the subpoena ducis tecum. While I'm happy to get into the details of why the subpoena ducis tecum is inappropriate, it's absolutely inappropriate. It's not even close. I do think it's important to just bring up the cases that are really, and these are well-established cases on these issues of judge bias. State versus Smith, 203 Arizona 75, 50 P third, I'm sorry, 825. State versus Myers, 117 Arizona 79, 570 Pacific 2nd, 1252. State versus Rossi, 154 Arizona 245, 741 P 2nd, 1233. I mean, these cases go back to 1977. The judges are presumed to be unbiased, and they're not presumed to be presumptive. It's the exact opposite. They're presumed to be impartial. And the case law further explains in great detail, and I have just 3 more cases I'd like to cite, Judge, that adverse rulings, which is really substantively what Mr. Gadget is relying on in his request. Adverse rulings, plural, in this case is 1 ruling, but plural, multiple rulings that are adverse, that are even set aside by special action or by appellate review, that is insufficient to justify any request for removal. The cases I'd like to cite in support of that proposition, and again, this has been argued in several discipline cases throughout history. Lightke, Liteky versus United States, 510 US 540, 114 Supreme Court 1147. It's a 1994 case. Costa versus Mackey, common spellings in both, 227 Arizona 565, 261 Pacific 3rd 449. That's a 2011 case. State versus Sharkart, SCHARKART, 190 Arizona 238, 947 P 2nd 315. That's a 1997 case. Simply put, Mr. Gadget has a lot of complaints against a number of people, none of which relate to the discipline case, none of which relate to Judge Vandenberg. having failed to procedurally and substantively brought this issue to the court's attention, and having just a defective pleading ab initio, we would ask that it be rejected. Thank you.
Okay, thank you. Mr. Gadget, did you have anything to respond directly to what Mr. Henley had to say? Not any new arguments, just a response to his statements.
He said specifically that the state bar is not representing Mitchell's interests. Okay, then explain this to me. His own words about me, quote, he intends to use these proceedings to continue to pursue his personal vendetta against the Maricopa County Attorney's Office, the Maricopa County Attorney, and her fiance, and certain Maricopa County Superior Court judges. As part of his vendetta, respondent requested the following improper blah, 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 blah. He used the word vendetta. He lied to you when he said it was me using it. He was the one using the vendetta, and he used the word vendetta directly to attack me because I'm exercising my First Amendment rights. I know I'm a foreigner. I know that. But, you know, I got nothing better to do, so maybe I'll go on Twitter and tell some stupid jokes. If he's not representing Rachel Mitchell, then how dare he write that line to me? How dare he say that to me? How dare he accuse me of a vendetta? Because I'm that stupid. I am that stupid. He says, oh, he doesn't care what I do in my private life. What do you think Twitter is? What is Twitter? I wasn't talking about any case I was working on. It's Twitter. That's the whole point. That is my private life. It's not a case I'm working on. They came after me, Judge. They came after me. They came to my house. He says that he just lied to you when he said the only basis of, or that I was copied on the email with the new subpoena. No, I wasn't. Part of my basis of my motion for a change of judge is ex parte communication. Cecilia Lopez admitted it. She said I didn't get the email with the new subpoena because they were going to ambush me, and PDJ was in on it, was because, oh, she forgot to hit reply all or something stupid like that. So when he told you right now to your face that I got everything that I was supposed to, he just straight up lied to you. He just straight up lied to you. He said that I was served. I wasn't served with anything. And he was so condescending when he said, oh, I'm going to give you the chance to do the right thing. Oh, thank you very much. To do the right thing. He had an opportunity to dispute everything else I've said about Jamal Pennington being framed, about me being the only lawyer in 100 years not to get due process. He didn't dispute any of that because it's beyond dispute. It's true. He did not dispute on being singled out as the only lawyer ever in America to be sanctioned for social media posts. He didn't dispute that. If there are so many problems with my subpoena request or the subpoena duces taken or the deposition, why didn't he object to them? Why didn't he say so? He filed nothing in response to my subpoena duces taken. And again, it's not the adverse ruling, it's the basis of the ruling. If you notice, Mr. Henley didn't even bring up the fact that PDJ said I didn't raise a prima facie case for the anti-SLAPP motion because it's obvious. Obviously, there's a prima facie case. One final point, Judge, is as far as the timing or the length of the deposition, he said he had a problem with me wanting to depose Mitchell for however long it was. I wanted to start the deposition at 9 o'clock for Mitchell. He wanted to start mine at 9:30. So how come me starting at 9 is so bad, but him starting me at 9:30 isn't? And why does he need to depose me? Why didn't he just come and knock on my door? Anyway, that's all I have.
Okay. Let me finish these last notes. I'm going to take this matter under advisement. I do want to look at the complaints, and in addition to the complaints, I also would like your responses, Mr. Gatchik. Could the State Bar provide both of those to me? The complaints and Mr. Gatchik's responses?
I think he emailed
Judge,
it last week.
Judge, I believe that Kendra just sent that out.
Okay,
The,
that could,
the complaint and the answer.
here, let me check my mail here. See if it's. Uh,
At 1:34 p.m.
Oh, okay, a little bit earlier here.
And Judge Warner, if there's
Here
anything
it
else
is.
that
I've
you'd
got
like,
one,
please let me know.
yeah, I've got 135. I have, that's something came in. It says, here's the answer and the complaint. Okay? And is that there's two matters listed, 240041 and 251216 are let me look. The complaint says 20, okay, that contains both of them within the State Bar. That's the State Bar numbers. The complaint number for the record is PDJ 259084. Are we on the same page, Mr. Gadget? Is that the correct one?
Correct.
Okay. And then I just want to real quickly look at your response to that, your answer here. Okay, and it appears to be a fairly, let's see, about 16 pages. Does that sound about right, Mr. Gadget?
Correct.
The one okay,
Correct.
okay. Well, I appreciate council's time and attention. I want one more clarification and probably clarify when I read the complaints, but at the time of the complaint that we're dealing with now, was Mr. Gatchik reinstated or was he still suspended?
Since his original and only suspension, he has been suspended.
Okay, so he hasn't Mr. Gatchik, you haven't reapplied?
That's when I tried to hire Will and check to do it, but you know what happened there.
Okay, so, okay, I thank you very much for your time, counsel, and I will issue a written ruling.
All right.
Anything else? Okay,
That's it.
appreciate
Nothing
your
from the State
time.
Bar.
Thank you. Bye.